Yeah, well, if you're getting arrested, the number one mistake is to actually speak to the police officer. Besides your name and your date of birth and your social security number and your address, that's what we call pedigree information. Don't say another word. Don't say anything. Don't try to talk your way out of it. Most of the time, when a police officer, a law enforcement agency, the FBI, Homeland Security is coming to arrest you, they've already formed their opinion. There is nothing that you're going to say that's going to say, oh, we made a mistake, goodbye. It's not going to happen. So you have a right to remain silent. We all heard it in the movies and on TV. Use it. It's a real right. And then you should always say, you know what, I want an attorney. I want to talk to an attorney. In this country, thank God, when you say I want to talk to an attorney, they have to stop questioning you. They may not question you anymore once you invoke your right to counsel. So I always tell people, don't talk. Only thing you should say is, I want to talk to an attorney.
Welcome to the Ellis Talker Show. If you enjoy our content, please like or subscribe.
I'm DV LeBron. If you have any construction needs, maybe you need a pergola or something done around a house or a roof, check out K&H Construction, a local guy, Chris Helms from Waxahachie. Please check him out. Let him know DV LeBron sent you. Today, my very special guest is Mr. Saul Bienenfeld. Did I say it right?
That's correct. Thanks, DV.
Thank you so much for coming on. Now, this is a different show that I normally do because I've covered different parts of the law, but there is two parts of this justice system. There's more than that, but there's two parts of this. And one of them is the prosecution and one of them is the defense. And when you're facing, a life sentence, you have things that you've been charged, it is a right that we're afforded to in this country to a proper defense so that we can fight the charges if we're innocent. And it's part of the justice system. Often when people get accused of crime, they're automatically presumed guilty, and it shouldn't be that way. Welcome to the show, sir.
Thank you so much. What a pleasure to be here. It's an important topic that we're going to be discussing today. The ethics and the reality and the humanity behind defending somebody who may or may not be guilty.
So you know what, and that's exactly why I wanted to have you on. Now, can you kind of give a little background on you, how you came into the law and getting to where you're at now? What brought you to defense?
Sure. Well, growing up, I always wanted to be an actor. And my parents would tell me, there's a lot of out-of-work actors in Los Angeles. I don't know why you want that career. And they were right, but I still wanted to be an actor. So I figured I could act in front of a jury. I could act in front of a judge. I'll become a defense attorney, a criminal defense attorney. I'll become a litigator. And I'll take these acting skills and I'll walk into a courtroom and I'll convince a jury why my client is not guilty. So I went to law school, loved it, loved every minute of law school. I actually went down in what's called an accelerated program. So I finished in 2.5 years instead of 3. My first job was in the Manhattan District Attorney's office. It's a pretty tough office to get into. And I was in special narcotics. So for 3 years, I was prosecuting drug cases. I then went over to the district attorney's, Robert Morgenthau at the time, and I said, I'm a little bored doing just drug cases. Can you give me something more exciting? He says, yeah, I have a bank robbery that no one wants. And I said, I'll take it. And tried a bank robbery case and a couple of other cases. And then I decided I wanted to go out on my own. I did about 1.5 years in a medical malpractice defense firm because I really wanted to understand medicine, and I couldn't go to medical school. So that was a great way to get into medicine. And then I went out on my own and I opened up a criminal defense practice, and I've never regretted it ever since. I treat my clients like human beings. That's the key thing. Tremendous amount of respect for my clients. Everyone has a different walk of life. Everyone has a different background. And believe it or not, there are some innocent people who get charged with crimes. It happens. And thank God, the innocent clients do get to go free if I'm representing them, because I don't sleep at night when I represent someone I know for sure is innocent. So much pressure on me to make sure that I win that case.
Now, I've been working in the criminal justice system for about 20 years now. On the side, after everything's said and done, they come to me. And so it's meeting all these different people throughout my life, all these different inmates and stuff like that. Some of them, yeah, so they probably should never see the light of day. But some of them you look at and you're like, whoa, this guy might actually be innocent. They all say they're innocent, but this guy in particular might actually be innocent. So you took a passion to helping these people out. What is the first mistake? Because when you get pulled over, that can be or when you come interaction with a police officer, that can be a tense time for the officer, obviously, and a tense time for the person being approached. So tell me, what's the number one mistake that people do when they're arrested, or at
It's
least talked to?
Yeah, well, if you're getting arrested, the number one mistake is to actually speak to the police officer. Besides your name and your date of birth and your social security number and your address, that's what we call pedigree information. Don't say another word. Don't say anything. Don't try to talk your way out of it. Most of the time, when a police officer, a law enforcement agency, the FBI, Homeland Security is coming to arrest you, they've already formed their opinion. There is nothing that you're going to say that's going to say, oh, we made a mistake, goodbye. It's not going to happen. So you have a right to remain silent. We all heard it in the movies and on TV. Use it. It's a real right. And then you should always say, you know what, I want an attorney. I want to talk to an attorney. In this country, thank God, when you say I want to talk to an attorney, they have to stop questioning you. They may not question you anymore once you invoke your right to counsel. So I always tell people, don't talk. Only thing you should say is I want to talk to an attorney. That's it. Because I find, I get people at all stages. I get people before when they're just under investigation and they haven't really been approached by law enforcement, and I tell them how to act if law enforcement does approach them. And of course, I get people afterwards who have already been arrested and they've gone through an arraignment and then they're looking to hire an attorney. And I get what's called statement notice, and it's all the statements they made. And I'm like, how am I getting it out of this? They try to get themselves out of trouble. I understand. It just never works. You can't talk your way out of an arrest. If the officer is planning on arresting you, go with the flow. We will deal with it. I know it's embarrassing. I know it's upsetting. I know it's time consuming, but we will deal with it. You're not in a position on your own to deal with it. So don't say a word. Shut up and call Saul. That's what I tell people.
Now some people try to litigate it right there when they get arrested, and maybe resist a little bit. What are your thoughts on that?
Never resist. You'll be charged with resistance of arrest. You'll be charged with obstruction of justice. If you lie to the police, you can be charged with another obstruction count. Every lie you tell them could be an obstruction count. They've already formed an opinion about you, and they're doing a job. If I was to send someone to the bank and say, go get $10 out of the bank, it doesn't matter how many people are trying to convince you, no, don't get $10 out of the bank. Your job is to get $10 out of the bank. Go do it. And it's the same thing. Their job is to make an arrest. Whatever you're going to say is just going to be used against you. It's not going to help you. It never does, and it never will. And that's the sad truth. But it's, I've been doing this for quite a long time, more than 30 years, and I've never seen anyone talk themselves out of an arrest. I have seen where people have called me and said, I'm getting arrested, and I go down to the precinct, and I could talk to the district attorney's office, and I could talk to the police, and I could talk to the detectives, and then I could have a case what's called DP'd, which means decline to prosecute. I've been successful a couple of times on those fronts, and they never go through an arraignment. They just get released, after being held for 20, 24 hours, because I know what I'm saying and I know what I'm doing. And I understand the whole case beforehand, and I understand the law. I understand I could convince the district attorney that they're not going to be able to prove this case beyond a reasonable doubt. Why put the guy through the system? So I've had a couple of successes with DPs, but I've never seen a defendant themselves, an arrestee, talk their way out of it, ever.
Before we move on, what is Miranda rights?
Miranda rights is the warnings. You sometimes see them on TV. When someone gets arrested, you have the right to remain silent. You have a right to an attorney. If you can't afford an attorney, one will be appointed for you. There was a case, United States versus Miranda. Anytime the police want to ask you a question and you're in custody, so it's called custodial interrogation. So you need two things. You need custody, which doesn't mean you're in handcuffs, doesn't mean you're in prison. It means you're not free to leave. And you need interrogation, which means that the police actually ask a question. Before the police could do that, they have to give you these warnings to tell you, you don't have to answer me. And if you want an attorney, you could get an attorney. And if you can't afford an attorney, we're going to find you one. And then they can ask you questions. A lot of police officers and detectives have you sign the Miranda warnings. So in other words, they have the 5 questions written down, and you write yes, yes, yes. That's how you waive your Miranda rights. It's also being filmed on their body cams now these days. With everyone has a video camera on their vest. So we see, later on in court, if it comes to, when a statement wants to be used against you, that you did waive Miranda. But it's a great case, and it really helps if you use it. If you don't use it, there's no point to it. So again, custodial interrogation. Now, what does it mean to be in custody? It could mean that subjectively you felt that with 2 police officers, one in front of you and one behind you, with their weapons, at their side, or even maybe in their hands, you couldn't leave. That's custody, okay? And then what's interrogation? That's asking a question. So the question might be, do you know John Doe? Did you go to this school? And they're trying to put you at a place, at a time, and a location so they can prove their case. They're not going to ask you straight out, did you rob a bank? They're going to say, do you know where Bank of America is on Central Avenue? Have you been there? When was the last time you were there? All these questions are going to be used against you on a bank robbery case.
Right. So when I have district attorneys on, and I sometimes have them on, and we talk about that side of the house. When it comes to those a lot of cases in the criminal justice system are pleaded out. A lot of them. It's a big thing in the criminal justice system to plead out. Now there's technical terms for that, but that's how I understand it. Pleading out cases. Talk to me about plea bargains and how you approach them.
Well, first of all, there's one of 2 ways that I find out about a case. The first way I could find out about the case is my client sits down and truthfully tells me everything he did. Okay? So I can make an assessment right away. Wow, this is going to be an easy case for the government, the district attorney's office, to prove. Okay? They're not going to need much. So maybe I should look for a plea. The other way is I get discovery from the district attorney's office, and I could evaluate, wow, this is going to be a very hard case to win, so then I'm interested in a plea bargain. And what a plea bargain is very simple. You're charged with a crime, and there are different types of crimes. There's a violation. A violation is like going through a red light, where it really doesn't count against you. You'll probably pay a fine and never go to jail. There are misdemeanors, where it's a lesser type of a crime, but you could go to jail for a year. And then there are felonies, where you go to jail for more than 1 year. And within felonies, there's A, B, C, and D, okay, and E. E is the lowest, A would be the highest. So if somebody committed a homicide or a rape, that's an A felony. You're facing 15 to 25 to life, and then it goes down to E, where an E felony, you could get probation, never go to jail a day in your life. I will listen to what they're being charged with. So let's say somebody's being charged with a C felony, for example, selling crack cocaine. That's a C felony. Mm-hmm. And my client tells me they're guilty. And the evidence has a video of him selling to an undercover agent, because now they do that. They video everything. And clearly you see that, a rock of cocaine is going from my client to the undercover agent. It's going to be a very hard case to convince a jury that that didn't happen. So instead of a C felony, because the court system is so overloaded with cases, I may be able to plead that down to an E felony. And as in terms of a punishment, he may never set foot in jail. And he might be able to do probation. And that's a great offer, and it's a great plea if I could get it. And I would convince my client, go ahead and take it. Try to get into a drug rehab problem, because you probably have a little bit of a drug problem as well if you're on the streets doing this. And get clean and, start a new life, but at least you're not in prison. Sometimes they listen, sometimes they don't. But the plea bargaining is there to actually help the court system get rid of a lot of cases, because there are just way too many cases and there aren't enough judges and lawyers to handle them.
Definitely. Now, Saul, you do this every day. I'm sure that you have thoughts on this. The perception is that if you don't have enough money, you're going to jail. If you have money, you can buy the best representation and you're not going to jail, so that it's skewed for people who have money and people who don't. You have to make a living. I mean, you're doing your job and stuff like that. Talk to me about your thoughts on that.
So there's 2 aspects of, how being, financially stable, capable, interact with criminal defense attorneys. The first is, people have a perception that if I can't afford one and one's appointed to me for free, the guy's not going to work that well. That's not true. Legal aid attorneys and county, what's called 18B attorneys in New York, are great. They're fantastic attorneys. I learn a lot from sitting in court listening to the legal aid attorneys. They do a lot of more cases than I could ever do. But that's the problem. The problem is you're one of maybe 300 clients that year that this attorney has, because there are so many people who can't afford attorneys. Whereas with me, you might be one of 30 clients, all right? Because I'm only taking clients that pay. So I could concentrate on your case a lot more than a legal aid attorney who has 300 cases in her head or his head and doing it. That's the difference. But they're highly competent attorneys. And they probably know case law better than me because they're in it every single day with 300 cases. Then you have the bail problem. And it seems that people are in jail on very low amounts of bail, and the only reason they're in jail is because they're financially incapable of raising the bail or having a friend or a neighbor or a relative put up the bail. That's really unfair, and that's where the Bail Reform Acts would come in and try to change that so that it's not just the fact that the poor people are in jail waiting for trial, but everyone could be out of jail waiting for trial, with Bail Reform Act. And there are weaknesses and there are strengths to it, but overall, it's a pretty good act.
Okay. Now, and bail is something that it's hot in. I'm in Texas, so obviously that bail reform doesn't play well where I'm at, and there's pros and cons and different things in crime. Now, I really want to get into the good stuff because you have represented so many people, Saul, and you've had so many stories. Talk to me about the case that sticks with you. There's got to be one that it hits you your whole career. It's always going to be with you. Talk to me about that.
So there are two like that.
Wow.
Yeah, we'll talk about the first one. The first one is a wonderful client. He was living with a woman who had a daughter who didn't get along with him. That's the bottom line. She didn't get along with him. And one day she tells her teacher, "He raped me." Horrible accusation. Client comes to me and says, "Never happened. It's not true. I didn't do this. This is so far from me being, who she says I am." I sent him to be polygraphed. He passed the polygraph test. I know it's not accepted in court, but he wanted it, and I figured, why not? Let's do this anyway. And we sat and we talked. And I found out from the DA that although she's not sure when this happened, right? But it happened in this month, and let's say it happened in August, okay? She saw it happen in August. She just know what date it happened. Mm-hmm. Was it a weekday or a weekend? I don't know. It just happened in August. Okay, so there's something to work with. So I went back to my client and I said, let's retrace your steps, every step you took in August. And the way we're going to do this is we're going to look at the browsing history of your computer. So we're going to see when you're in front of your computer because it has times and dates. We're going to look at every receipt on your credit cards. We're going to look at where you were, what you do, the times on the receipts. So if you went shopping and the receipt says, you left the store at 3:30, it took you, and we see 15 items on the receipt. It took you at least 15 minutes to get that. So now we have, and I created a timeline as an alibi, every single place he was, to show that he could not have possibly done this. He didn't have the time or the opportunity. I then sent, because she said it happened in her bedroom. I then sent an architect into their apartment, okay? And he mapped out the entire apartment and drew up a model of the apartment. One of those models that you see architects do, like a 3D model.
Okay.
And we measured the walls because she says she was in her bedroom and her mother was in the other bedroom, which has a connecting wall, and the headboards, the beds are next to each other. We had that. And that She screamed. And that she screamed also. She testified that she screamed. And I spoke to the mother. And the mother says, "I don't believe my daughter." That was big. And the mother says, "I don't believe your daughter." And I took all this information to the district attorney. And I had one more piece of information. And that is that this little girl was examined. And the examination said that her hymen was intact. And she claimed that it was penetrative sexual intercourse. Okay? So now I had medical proof also that what I believe then makes it a no-brainer that she's lying about something. I brought it all to the DA, and the DA said, "Sorry, Saul, you're not convincing us. We're not convinced."
Whoa.
Yeah. So I was like, okay, in that case, we're in New York. You're entitled to have a grand jury hear the evidence.
Mhm.
Now, there's a famous line by Justice Cardozo that says a grand jury could indict a ham sandwich
Right.
because they're just a rubber stamp. They just say yes, yes, yes to everything, and they're not interested. And I sat down with my client and I said, would you be willing to testify in the grand jury? Now, most defense attorneys would tell me, you're
Don't
making
do
the biggest mistake in the world. Don't do it. Don't ever do it. And I said to him, I said, I want you to know that most defense attorneys will tell you this is the biggest mistake and don't do it. And I want to tell you why. The reason why is because you're going to be locking yourself into a defense and you could never change it. And if you're willing to do that, I'm willing to put you into the grand jury. But I want to prepare you, and I want to prepare you for everything you're going to say. And he said, yeah, I want to do it. I said, great. So I prepared hours and hours and hours with him for his testimony in the grand jury. He finally has his day in the grand jury. He explains everything to the grand jury. He even tells the grand jurors, by the way, call the girl's mother as a witness. She's in the hallway. All right. And this is a Brooklyn grand jury. So they're going to do whatever they want. You know, they don't care what a DA says. So when he left, the DA came outside and said, yeah, they want to hear from the mother. I'm like, oh, okay. She happens to be here. I knew she was there because I told her to come. Right.
Right.
She wasn't on their witness list, but he said to them, call the mother. And the mother went in and she testified, as I knew she would, saying, I don't think my daughter's telling the truth. My daughter has a tremendous animosity. She hates the fact that I'm living with this guy. You know, she's upset that I divorced her father. And I personally don't believe my own daughter. And if she would have screamed and I was in the apartment, I would have heard it because I could hear her giggling when I could hear the TV on. I could hear the radio on from her room into my room. If there was a scream, I definitely would have heard it. Grand jury came back with what's called a no true bill, which means that they're not going to indict him. So the case gets dismissed. Now, my biggest problem was you're allowed to go in to get another grand jury. But this DA decided at that point, I'm not interested. Saul, you won, and your client walked away a free man. And that's what happened. And to this day, he sends me a Christmas card every year thanking me. It's very nice.
You saved his life, basically. You saved his life because that would have been a rough one. Now, 30 years of doing this, Saul, you know when somebody's lying to you. I mean, you must be the best lie detector ever in the history of man by now.
Yes.
Because you're talking to all kinds of these folks. When have you ever had to represent one and knew this dude is completely lying to me? And how did you treat that as far as trying to defend this person?
That's even easier. Because at that point, what I'm saying is, you know, my role as a defense attorney is basically, listen, the Constitution doesn't say you get a fair trial if we like you. Okay? It says everyone gets a fair trial. All right? It's not some abstract principle, right? It's what stands between democracy and a police state. So my job is to hold the government to its burden, to make sure that every search, every statement, every piece of evidence is lawfully obtained, that every confession wasn't coerced, that every right to counsel, to silence, to due process is always protected. So when I challenge an illegal search or cross-examine a police officer, I'm not helping crime. I'm helping the Constitution do its job. And that's how I see my job when I'm defending somebody who I know is guilty. It's to defend the Constitution, not necessarily defend the individual. Okay? I'm defending the Constitution. And I'm protecting everyone else who's innocent by defending this guilty person to make sure that the Constitution of the United States is upheld.
When you hear that, because writing on what you just said, when you hear, oh, we got him off on a technicality, this guy's walking on a technicality, what are your thoughts on that?
You know, most of my clients are not monsters. They're people who made terrible decisions, often in moments of fear or addiction or desperation. You know, I've represented addicts, I've represented veterans, parents, doctors, people who once sat on the other side of a courtroom. Defending them doesn't mean I excuse what they did. It means that I see their humanity. And in a system that dehumanizes the accused, that act alone is revolutionary. So that's my job, you know, is to represent humanity, to represent the human side of somebody. So go ahead and, you know, say it's a technicality. but my job is to defend the Constitution and defend humanity. That's what I'm doing.
What is one case that stuck with you because you know this dude or woman was innocent? You know it. You feel in your bones. 30 years tells you this person is innocent, and it just didn't go that way.
Well, luckily, it did go that way for my innocent clients, because I don't sleep when I represent someone who's innocent. It did go that way with all the people that in my gut said was innocent. But I fight like hell for everyone. I don't let the fact that I might think someone's guilty or they are guilty, stop me from fighting as hard for them as I do for the innocent ones. I might lose a lot of sleep when I defend innocent people, but I fight just as hard for the innocent as I do for the people who I may or may not be guilty. But I will tell you another very interesting story that I defended a woman once, an elderly woman from Washington Heights who was accused of bank robbery. When I met this woman, I was like, there's no way that she did a bank robbery. Like, you think of bank robbers, with the ski mask and the guns and everything else. They say that she went ahead and she passed a note to the teller. I said, it just didn't happen. So I did a lot of things. One of the things I did is I found the note. They had a copy of the note. And I went to a graphologist. That's someone who's a handwriting expert. And I said, this is her handwriting. This is the note. And the graphologist said, this note was not written by this person. So, the Secret Service comes back to me and says, well, she could have had someone else write the note, but we think that she's the one who passed it. So I go ahead and I get the video footage. And the video footage looks a little bit like my client, but not exactly. There's something about that that's just, it's sticking to me that this might not be her. Okay? It wasn't very clear video footage, obviously. But one thing in the video footage that I did see is that at the moment that this person, whoever did pass the note, was walking out of the bank, two Brinks drivers were walking into the bank. They passed each other. So I said, wow, let me go find these Brinks drivers, interview them, and see if they remember who this person was. Because they walked into a robbery. They walked into a bank robbery. Maybe they remember. So I found them. They're both former NYPD police officers, which was great. Okay. And I actually brought my client with me. And I said, the person who walked out of the bank when this robbery took place, do you remember who it was? We remember it. Do you remember what the person looked like? Yeah. Is it this person? They said, absolutely not. I said, you're trained in identification? She says, when we were in NYPD, that's what we're trained in, how to identify people. And this is not the person who walked out of the bank. I said, great, come on down to the Secret Service and talk to them. And that too was eventually dismissed. They dismissed the case and they did not prosecute my client.
Wow.
But that's a lot of legwork to get to that point.
Yeah, you gotta be on the details, is what I'm gathering. Like, the details matter definitely when it comes to these things. Now, what is the most challenging thing you see approaching the criminal justice system now?
You know what? It's probably the use of AI, artificial intelligence.
Yes.
I have clients that put their case into ChatGPT, come back to me and say, I'm innocent. ChatGPT says I'm innocent. I'm like, okay. But ChatGPT is not the judge and he's not the jury either. That's the problem. I've been doing this for almost 40 years. And, we got to work a different way to do this. But at the same time, a lot of AI, the police are using it as well. So the police will have AI determine, high crime areas, what they should be looking for, where they're patrolling. And when they do that, they're not looking at the low crime areas where crime might be taking place. They're concentrating too much on high crime areas. AI is doing a lot of facial recognition, and facial recognition is only as good as the data that you put into the AI. Facial recognition is not perfect, game either. By the way, when I did the bank robbery case, we didn't have facial recognition. I wonder what would have happened if that case came up today where we do have facial recognition. There's a lot of AI issues that people think, well, if AI said it happened, it must have happened. And that's not true. Wow. But I think that's going to be the next biggest challenge.
And then now AI can, you can mimic anything. It no longer is, we grew up in a different generation, Saul. And if you saw it on video, that's what it was. Now, if you see it on video, it isn't necessarily what it is. So now when you're doing these kind of cases, do you have to review to see if AI messed with anything?
If I suspect that it did, I will bring in an expert to look at the footage and determine if it's AI or not. Experts can see the difference right away. It's not that perfect, um, but it does convince people otherwise. One of the interesting things of AI, I do a lot of sex crimes defense work as well. So, as we know, there's something called CSAM, child sexual exploitation material, and that's having naked pictures of minors. But you could go into AI and tell a computer, show me a picture of a 12-year-old girl naked. And the AI could produce it. They shouldn't, but they do. Now the question is, are you guilty of producing sexual material or not? And that's going to be the next frontier of
Oh
CSAM,
wow. Oh wow.
right?
So
It's not.
I mean, it's an abhorrent act. I mean,
It's a
it's
boring act,
act no matter
but
what.
the defense is going to say there's no real victim. It's not a person. It's a computer generated image, but it looks very realistic. I mean, I'm sure you've seen the AI, videos of people walking around, and it's very realistic.
Yeah, yeah. No, I mean, I've seen videos. You. Some of it is so good. You're just like, well, that person is AI. Yeah, they have even recently they were talking about some lady who's doing their acting. They're literally going to do movies with this lady who's AI. She's AI created. She doesn't even exist. And it's just like, it's crazy the frontier that's going in, and you having to deal with that in these criminal cases. The last thing I wanted to ask you is what what is the most who is the most challenging entity to defend defendants on? Because obviously I'm on one side of the law, and I've heard once you can't outspend the federal government. And when they come down on you, supposedly, like, for you got Southern District of New York. They're legendary. These people, if they come after you, got to help you. Talk to
They're
me about
legendary.
defending.
They're brilliant. They're extremely wealthy. The deepest pockets any law firm could possibly have because they have the whole U.S. government behind them. Okay, and they have about a 97 or 98% conviction rate, so they win every case. And they do that because they're extremely prepared. They don't bring a case until they're 150% prepared. They know exactly what's going to happen. They've run all the different challenges. The only way to beat, a case like that is on technicalities. That one of the agents may have made a mistake, and that's what you have to look for. That's how you're going to beat a case brought by the federal government. Because yes, they're going to outspend you at every single turn. You hear every once in a while, like Sean Combs was found not guilty of the most severe charges, which is great. I'm very happy. That's the way it should have been. That's the proper verdict. I'm surprised that they even brought those charges against him, but he was convicted of, two lesser charges of the prostitution charges. But it was a terrible loss to the government that they lost those conspiracy charges. But I think that they overcharged the case. And one of the problems is that the government tends to overcharge cases because they think that they're so powerful that they're going to get a plea anyway. So might as well overcharge. And when people challenge that, you get a jury that comes back and says, listen, we don't think there's conspiracy here, but we do think that was, transportation for the purposes of prostitution. And, that's a perfect example of what happened, recently. So that's a very tough adversary to go up against. There are some DA's offices that are very bright. There are some bureaus that are very bright. They don't have the resources sometimes to bring cases properly, to get the proper experts, to get the proper lab technicians. A civilian could outspend them. Let's put it that way.
Yeah, and that's not going to happen with the federal government. They
Right.
just
You know what? A great example of that, the civilian outspending you, is the O.J. Simpson case.
yeah,
They put on a great expert, but OJ found a better one. You
yeah,
know,
yeah,
he had a lot of money. He spent it. He had four of the top defense attorneys in the country working on him. And he won,
yeah.
rightfully so.
No, there was recently, and I don't remember what case it was, where this judge. I'm sorry, there's just so much. I'm starting to get in a groove of this right now. There is a when they were looking at decisions, the jury came back and said, no, we can't decide on arrest, and that's where we're hopelessly deadlocked. And the judge is kind of nudging them, sending them back, saying, you will get a decision, you can look at this one if you don't like that one, but go back in there and kind of nudging. Is that even legal? How could they do that?
Yeah, it's called a hung jury when they say they're hopelessly deadlocked. They'll come back with a note, we're hopelessly deadlocked, and the judge is not accepting it. The judge wants a verdict. They worked very hard on a case, and the judge says, I'm not going to allow this to be a hung jury. I want you to work on it. And the judge is not allowed to ask, what's the vote? Is it 6-6? Is it 11-1? He's not allowed to ask. But he gets a feeling. You get a feeling, sometimes, who the holdout is or who the holdouts are. And then you try to tailor your comments to that person, continue deliberating, listen to other people. They're allowed to do all that stuff. What they're not allowed to do is convince them, who's right or wrong, because the judge doesn't know who's right or wrong. That's why the jury's there. They're the finders of the fact. The judge is only the finders of the law. So yeah, I've seen it happen a lot where they'll come back, they'll say we're deadlocked, and the judge will say, well, I'm not accepting it. Go back. But after 2-3 days, the judge says, you haven't made the decision yet, and we will have a hung jury, or we'll take a partial verdict.
It's just this whole system. I mean, I could speak to you about hours. There's just so much to it. I mean, God knew why he put me where he put me, and not as an attorney or counselor, as they say back east, back in the day. That's why he knew why he didn't do that. But I do appreciate you coming on the show. Hopefully I could have you on again and talk about ghost dope and some of the other things that I've heard in my life, and talk about those things. Can you stick around real quick after the show?
Definitely, of course.